Have you or someone you know been charged with a crime, DUI or misdemeanor, and you're wondering how to get the charges dismissed? If this is something you've thought about, I'm about to tell you 5 ways that criminal charges get dismissed. Hi, my name is Daniel M. Rosenberg. I'm a criminal defense attorney and the founding partner of Rosenberg, Perry & Associates, and one question that I commonly get asked repeatedly is, Daniel, how do I get my criminal charges dismissed? I've been charged, a friend's been charged. How do we get this to go away? Well, keep watching this video and I'll tell you 5 different ways that criminal charges can be dismissed. So let's get right into it. One way that criminal charges are dismissed are due to a lack of evidence. So that may seem obvious, but let's put a finer point on that. If you're charged criminally in the state of New Jersey, and that means felony, misdemeanor, DUI, the state has to prove your guilt beyond a reasonable doubt, and you are under absolutely no obligation to provide a defense. It is up to the state, and solely the state, to prove their case. If they don't have enough evidence, they can't prove their case. So by way of example, if they think you did it, if they know you did it, but they can't prove it, that's not guilty, that's a dismissal. And as a criminal defense law firm, it is our charge and obligation to not only seek that out, but if there is a lack of evidence, to convince the prosecutor to do the right thing. A second way that criminal charges are dismissed are due to the suppression of evidence. So they may have enough evidence to prove your case, but has that evidence been obtained lawfully? For instance, if there's evidence that's seized, that evidence needs to be seized lawfully. There needs to be a search warrant or an exception to that search warrant. If the search warrant is in violation of the law, a motion to suppress is filed. The motion to suppress keeps the evidence out, and therefore that evidence can't be used against you in your case. This is often referred to as fruit of the poisonous tree. Some of the evidence that could be suppressed is evidence found in your car, whether it's a firearm, drugs, weaponry. Other evidence that could be suppressed is your statement. If you provide a statement but it's in violation of your Miranda rights, that statement can be suppressed as well. So a motion to suppress will keep evidence that's been found against you out of the case. Without that evidence, they can't prove their case beyond a reasonable doubt. Case can get dismissed. A third way that criminal charges are dismissed are through diversionary programs. In New Jersey, there are several different diversionary programs. One is called pretrial intervention. Another one is called conditional dismissal. There's another one called conditional discharge, and there are some other diversionary programs. In essence, you avail yourself to these programs. You comply with the program for a period of time, and at the completion of the diversionary program, the charge is dismissed. A significant benefit with diversionary programs is that it gives you some level of confidence that the charge is in fact going to be dismissed. So long as you complete the program, the charges are dismissed, you can have your record expunged. Worthy of note is these diversionary programs are one-shot deals, meaning once you use it, you can't use it again in the future. A fourth way that a criminal charge can be dismissed is through what's called affirmative defenses. A classic example is self-defense. Yes, I in fact struck this person. Yes, I caused injury to that person, but they initiated this and I used lawful force and response in order to defend myself. Therefore, even though I was charged with the crime, even though I committed an act of violence against this person, all the charges against me are dismissed. Another example of an affirmative defense is an alibi. Hey, I wasn't there. Here's proof that I was at work on the date and crime of the offense, so therefore I couldn't have committed it. You have a viable alibi or self-defense claim, your charges can be dismissed. The fifth way that criminal charges can be dismissed in criminal court is through a violation of the law, more specifically, a violation of the statute of limitations. In New Jersey, most criminal offenses, or felonies, have a 5-year statute of limitations. That means that the state has 5 years from the date of the offense to file the charge. If charges are filed after that 5-year period, then the charges can be dismissed for violating the statute of limitations. There are lots of nuances that can be utilized to file these types of applications, so having an experienced criminal defense attorney review your case and your circumstances is critical. Now, there are dozens of other ways that your charges can be dismissed. These are just 5 ways that criminal charges are dismissed that we see very frequently in our practice. So if you or someone you know has been charged with a crime, offense, or DUI in New Jersey, contact our office. We'll take the time we need to evaluate your case and give you an honest and straightforward assessment of what your options are. And if you like this video, please like and subscribe to our YouTube channel. And if there's a question or issue you'd like to learn more about, please contact our office. I'd love to hear about it. We are criminal trial attorneys. We have your back. That's what we do.